Well, our coverage continues right now on the historic Supreme Court ruling on same-sex marriage. The justices today giving gay couples the right to marry nationwide. And joining me right now with analysis of the court's decision, Curt Benson from Cooley Law School. Thank you once again for joining us. Any surprises here today?
Well, not really. It was a very sweeping decision, and most, the smart money has always been 5-4, Justice Kennedy writing the opinion. Justice Kennedy is actually, people don't realize this, he's a fairly conservative justice, especially economically. He's appointed by Ronald Reagan. But he's always been extremely open to the gay community, and he's always been their friend going back 10, 15 years now. So everyone kind of knew he was going to write the opinion, and everyone knew that he was going to side with those people, those proponents of same-sex marriage. So in that sense, it was not surprising.
Right. It was a 5-4 decision, and it was interesting reading some of the comments and the opinions.
Well, Justice Scalias noted, for example, he wrote a dissent, not surprisingly, and he's noted for being a very sharp writer and being somewhat sarcastic. And in this particular occasion, Justice Kennedy is not what I would describe a gifted writer. He's very difficult to slog through one of his opinions, but he does favor the soaring rhetoric about the dignity of marriage, the personal autonomy of marriage, and this kind of stuff. And same-sex couples simply want to enjoy the benefits that you and I, for example, take for granted, all of which is defensible. But what Scalia was saying, look, this soaring rhetoric is hiding the fact that you really have no constitutional basis to come up with this, that you're really just making policy, which is what legislatures are for. At least that's what Justice Scalia's opinion, joined by, of course, Chief Justice, as well as Justices Thomas and Alito.
Right. It was interesting to read some of that. So really, this takes the entire question of marriage away from states.
Well, it really doesn't. I mean, again, you're right, and that was what the states were arguing, saying, look, the states have always defined what marriage is. The federal government has rarely had any kind of a role in marriage. Again, you don't go to federal court to get divorced. You don't go to a federal judge to determine child custody issues. And what the court said is, we're going to leave marriage with you, states. I mean, you're in the business of marriages. We're just saying you can't create laws pertaining to marriage that conflict with the 14th Amendment of the United States Constitution, and therefore any law that conflicts with it will strike down. Hence I don't know how many dozens of states have laws against same-sex marriage. It was stricken down as a violation of the 14th Amendment. The states also argued, look, we define what marriage is. The federal courts have never defined it. And around and around we go, but this is how it came out, and now it's settled.
Moving forward, do you see any fight to this?
Well, I do. I see, first of all, there's some other issues that haven't been resolved. Adoption, for example, which in Michigan is what brought this case to the United States Supreme Court. Can they pass a law saying, okay, you can marry, but you can't adopt? I expect there'll be a lot of conservative legislators who, much like in response to Roe versus Wade, will attempt to, regulate in such a way as to discourage same-sex couples from marrying. I think they'll be relatively short, ineffective, and I think eventually, like it or not, this is a law of the land, unlike the Roe v. Wade, which has never been accepted by a great many people. I think eventually this is going to be the new normal, and 5, 6, 7, 20 years from now, we will barely remember this day.
Right, won't be talking about it. Okay. Curt Benson, thank you so much for joining us from Cooley Law School. We appreciate